Today I'll be touching on the topic about asset protection, particularly for business owners. So just a quick introduction. I'm a estate and succession practitioner with Precepts Legacy, and apart from wills, we also help clients with trust and LPA planning. So do you know what happens when to your assets after your passing? Does anyone know? You can type in the chat box. Go to children. Okay, first things is your assets will be frozen. So if you do not have a will, our government will decide for you who gets the money, no matter whether you like the person or not. If you have a will, you get to decide who and how you like to distribute your money. However, do take note that for HDB and CPF savings, they will not be distributed via a will. So what if you are business owners? You may ask, how will your share ownership be handled? Anybody who know? Okay, first things just now, since we mentioned the assets will be frozen, so are the share ownership with Accra, right? But then more importantly, when the share ownership, if need to be transferred, that will be frozen and pending for grant of probate, which easily may take up to 6 to 9 months. And during this period, who will sign off the checks for you for the vendor's payment? Without settlement, would the vendors stop supplying goods and services due to lack of successor? How about the banks that you have relationship with? Do you think the banks would continue to extend the loans and credit facilities even when the personal guarantor already passed on? And in that case, if the bank start recalling the loans, right, can your company have enough reserve to redeem the outstanding balance? And how long can your company continue to pay for office rental and staff salaries without sales coming in? And what will happen to the staff morale? Without the key employees, if we can take this one step further, who is then to collect the account receivables that may be overdue more than 90 or 180 days? And all this, right, will expose to solvency risk to the company. The key question here is, would you want to sell the company at such timing? Won't you be facing a huge loss? So imagine that company that is already set up by you, that you put in your heart and soul, right? It may be a very leaky, like a leaky pill over here. So the next question, what if you are a business owner with a joint partnership? So there could also be potential dispute over valuation of your shares. Do you have already a pre-agreed business valuation or buy-sell agreement with your existing partners? If not, does your family member know how much is it worth? Because there's no such agreement, right? Do you know that is it possible that for your family members to accept something like a 50K cash offer for your share that could easily worth, let's say, 1 million? Or the other way around is if it's your partner's passing, do you have that 1 million in cash readily for that buyout? Does your family know how to run the businesses? Because if the company requires additional loan at that point in time, there may be a need for the new shareholder to be the guarantor. So in that case, are you helping or exposing your family members who know nothing about the business to huge risks? And we haven't mentioned about, let's say, if they are different directions by the different the new shareholders, right? Who should your staff take instruction from? There will be also some concerns, valid concerns, such as some may worry or concern about the partners may unethically transfer company assets or business externally, leaving the company with no physical assets or value. If it's your partner's passing, would their family members be selling their share to your competitors and therefore exposing sensitive trade secrets? So in the end, the worst case scenario, it might be the best option for family members to forego the business altogether in that scenario, if without proper estate planning. So here is an example, a news article years ago. This happened. Anyone heard of the name, the restaurant, by the Swan Tao restaurant? So in short, the business owner passed away at the young age of 38. By then he's 13 to 14 over restaurants outlets, right? At that time was valued about 20 million. At his passing, he has a liability of about 6 million. So make a guess, how much, if today you are the beneficiary or the spouse, how much would you be willing to let go? So probably 20 minus 6, so 14, around that. But to your surprise, okay, to many surprise, the surviving spouse, right, of this business owner actually just take a token sum amounting to about 5 digits, yeah, for the whole chain, because spouse is not involved in the business and do not know anything about this. So it's a very sad cases whereby estate planning for businesses is not done properly. So over here, a will may not be sufficient for business owner, but what is more important is having a structure that you can appoint a corporate trustee and executor to represent on your behalf. So this including hiring a business manager or a salary director, right, to look after your businesses while waiting for your children to take over, or simply looking out for a buyer for exit plan. So therefore, to achieve all these assurance of your business value and legacy preservation. So some may be asking, if this is so important, why aren't every business owner doing it? So it really depends. Some could be a very sensitive topic, some may not be ready. So it depends on the priority at that point. Some conversation starters, for example, dear Mr. Client, if you're no longer around, the business value may be worth a lot lesser. Will you want to sell it at such timing? But because this will be an added losses to your family members. Or sometimes when you hear clients sometimes complaining, you see lah, if I'm not around, what will happen to the business? Yeah, so these are some of the telltale signs that we should look at in terms of estate planning for business owner. So the other one, let's say for business owner with partners, right? Hi, Mr. Client, as you have other business partner, have you ever thought of, are you willing to do all the work but only receive half of the profits in the event something happened to your partner? And for how long will your company continue paying the other partner who is deemed unable to work? Is your company capable of paying all these expenses? And lastly, you could end it with, let me introduce you to my partner, Joseph, who is an estate planner. He can certainly help you with the planning, so both of your family and business value can be protected. Thank you.